I know we're bumping right up across the 1 o'clock hour, but if there's any quick questions, we'll take them. Yes, sir.
With respect to confidentiality of settlements, it's in other contexts as well an issue that's of concern to members, especially where information connected with the defendant's liability may be a matter of public interest, such as a dangerous product or other activities. Would either of you be in favor of legislation which required courts to make public those details in a settlement where there was a matter of public interest at stake? For example, you do a lot of defense. Would your clients be willing to have the details of their settlements and under non-bankruptcy law? Is that something you think would be useful?
Well, you've got to look at, the reason we have a settlement privilege is to make sure we don't chill people's enthusiasm for sharing information during settlement discussions, but the privilege is actually fairly limited. I think in most of our cases, obviously the facts of exposure and the basis for the assertion of a claim against us is not something that we would necessarily view as confidential. The settlement amounts, at least as a threshold matter, we like to keep confidential just because we view that as commercially sensitive information that other plaintiffs' lawyers would want to know. I'm not sure at the end of the day it's really that important because as Nate and I were talking beforehand, he can probably tell me with some degree of accuracy what my settlement averages are state by state across the nation, and most of the competent plaintiffs' lawyers I deal with know that because there's a fair amount, despite confidentiality, there's already a fair amount of sharing. So I think, and this is one lawyer's view, I'm a strong proponent of sunlight and settlements. When I look at a number of class action settlements that have been approved by courts with material provisions kept confidential, I'm appalled. That shouldn't be happening. I think the more information that's made available as sort of reflecting the results in the court system, the better we are.
I think when it comes to issues of public health, that's a policy issue. As a lawyer for plaintiffs, our job is we have a fiduciary obligation to our clients to maximize their recovery within the bounds of the law. And if a defendant is going to say, look, we'll only pay you what I would recommend to the client as a reasonable settlement if you agree to a provision that says we can hide the fact that we've been doing bad things. I think under the ethical rules of a lot of jurisdictions, I have to recommend that settlement, notwithstanding the fact I may personally think that's a bad idea. In terms of public health disclosures, I think if there is wrongdoing by a corporation, it should come to light. But whether or not you need federal legislation to deal with that, I don't know. Like I said before, I'm a sort of a big believer in the limited federal government into something like this, and I think it depends sort of on a case-by-case basis whether you would need, a judge can always say, look, I'm not going to approve this settlement if there is a provision in here that makes something that, if for example, a corporation was poisoning the water in some community and they want to keep that silent, a judge can say, look, I'm not going to approve this class action settlement even if both parties want to agree to it because this is a public health danger. It's just like, the attorney-client privilege isn't always absolute. If your client comes into you and says, I'm going to go blow my ex-wife's head off, that's not privileged anymore. So you can always, vary it. And I guess, Nate Finch, personally, I am probably in favor of more sunlight into corporate wrongdoing, but whether or not you need legislation to address that issue in the context of settlements, I don't have enough knowledge or view to know.
Hang on, is there any other questions? Yes, sir.
There are a couple layers to that. First of all, and this isn't, I think, just defendants. I think plaintiffs fought this war early on, too. One of the huge drivers of asbestos use was the federal government through the military. Fairly late in the day, if you were building ships for the United States Navy, you had to use asbestos in a wide variety of applications. Because of sovereign immunity, those claims have largely been unsuccessful. And I think by certainly the 70s, people had stopped trying to sue the federal government. The regulatory response to asbestos, I think Nate and I would concede, was probably slow. OSHA put emergency regulations in place in 1971. But keep in mind, like all scientific knowledge, the awareness came at varying degrees as to different kinds of disease, different applications. I think the risk of asbestosis was certainly well known in the 30s. Lung cancer came somewhat later. Mesothelioma, because it's such a rare disease, I think the science was slow in developing, but I think by the 60s there was pretty good information there. But the seminal work that Irving Selikoff and others did at Mount Sinai, which really sort of blew open the whole idea of asbestos health risk, even those doctors, I think, thought initially that it was going to be largely restricted to the insulators, the populations they were studying, because they were in, they called themselves the snowmen because they were covered with asbestos fibers. And it took a while, I think, to understand that there was a lower level of asbestos exposure which could still have very serious health consequences. So, we fought the regulatory side. I think, when OSHA got involved, the regulations were probably inadequate initially. And one of the other burdens we bear in asbestos is these long latency periods create a huge temporal disconnect between the exposures and the behavior and when the disease is manifest. I mean, we are talking about people who were exposed 30, 40, 50 years ago, and trying to reconstruct what the world was like at that point in time can be difficult.
I think regulation, generally speaking, is a crude tool to regulate companies' behavior in the sense that the government sets a lot of regulation. You don't want to over-regulate something. I mean, we set speed limits. Speed limits are 55 miles an hour, 70 miles an hour. A lot of people are going to die on the highways, even though we know, 70 miles an hour isn't a safe speed. I think it is, again, coming at it from a states' rights, limited government, Jeffersonian perspective, I would much rather have, if a company makes a toaster that blows up in people's faces, to allow people to sue the toaster manufacturer and be on an equal footing in front of a jury than to have a federal department for designing toasters. Now, asbestos is somewhat different from that because it is such a huge problem. And the regulatory response, I agree with Mr. Stengel, was slow, in part because a lot of asbestos manufacturers did everything they could to slow down the governmental response to it. Like I was saying before, asbestos has not been banned in the United States. I mean, there are regulations that say if you keep the level of exposure below X, you're not likely to get asbestosis, which is a lung scarring disease. But none of those regulations protect against cancer. And so it's very difficult to cure a problem through the regulatory regime. I'm in favor of, I think most people don't want poisonous chemicals in their food, in their air, in their water, but regulation can only do so much. And that's why I think a strong civil justice system is the flip side that has to be there to allow ordinary people to be on a level playing field with whoever, whether it's the government that poisoned them or a large multinational corporation.
So usage of asbestos just in general, is it still considered legal in the construction industry?
It is still legal to make, with a few exceptions. You can't use asbestos-containing joint compound. The Consumer Products Safety Commission outlawed that in 1977 over the objection of the joint compound and manufacturers. You cannot have asbestos-containing insulation. But there are lots and lots of products that if companies wanted to make them today, they could. You could have asbestos floor tiles. The car companies didn't, and brake companies didn't take asbestos out of brakes until 2001, 2002. Gasket manufacturers were still making asbestos-containing gaskets up until the year 2000. So the short answer is it's still legal to make asbestos-containing products. The reason people don't in the United States is because of the civil justice system and state court juries. The risk of going before a state court jury and trying to defend why in the world you'd use asbestos in your product in 2000 is a big deterrent. The flip side of that is asbestos is still exported from Canada all over the world, and it's used, by unsuspecting people in a lot of third world countries, and the death toll from that is going to be enormous by the middle part of this century.
Well, with that, we'll call it a day. I appreciate you hanging in there with us. We appreciate you attending our event, and we look forward to seeing you at future events.
One thing I'd
Yes.
add, to the extent of you have any continuing interest, which may be remote, there was a hearing before the Subcommittee on the Constitution of House Judiciary in September, and there were written statements by both plaintiff and defense lawyers, which will go into this in more detail and probably point you in the direction of reference material if that's of interest to you.
Well, help me thank the panelists.
Thank you very much.